Today, we're diving into the archives of the International Court of Justice for a really fascinating case from 1956. It's a story that has it all: the Cold War, individual rights, and this incredible moment when a huge international organization, UNESCO, was challenged at the highest possible level by its own employees. So let's unpack how a simple dispute over a job contract blew up and went all the way to the world's highest court.
All right, so here's how we're going to walk through it. First, we'll look at the loyalty test that started this whole mess. Then, the first round of legal battles between UNESCO and its staff. After that, the dramatic appeal to The Hague, the final binding decision from the court. And finally, why this case set such an important precedent for justice.
Okay, so you have to picture the early 1950s. This is a time of intense suspicion, of deep political tension. The Cold War wasn't just being fought with armies, It was this ideological battle that crept into every corner of society, and that included these brand new international organizations.
So imagine this. You're an American, you're working for an international organization in Paris that's dedicated to peace and education. And then, out of nowhere, you get a demand from your own government back home. Your answer, or even your decision to stay silent, could cost you everything. Well, that is exactly what happened to a man named Peter Duberg, who was an employee at UNESCO headquarters.
Here's how it all went down. The US government started running these loyalty checks on its citizens working abroad. Mr. Duberg and actually 3 of his colleagues were called to appear before a US loyalty board, and he refused. He basically said that his primary loyalty was to the international organization he served, not his home government in this context. He told his boss, the Director General of UNESCO, what he had decided. The response? It was fast. The Director General decided not to renew Mr. Duberg's contract, saying his refusal didn't meet the high standards of integrity they required.
So, and this is a really crucial point, Mr. Duberg wasn't technically fired from an existing contract. What UNESCO did was they just let his fixed-term contract run out and then refused to give him a new one. So, for all intents and purposes, he was out of a job. Case closed, right? Well, not so fast.
This is the moment the story really pivots from being a political issue to a full-blown legal battle. See, the employees decided to fight back, and their whole case, it turned out, would hang on one single, crucial internal memo that somebody at UNESCO seemed to have forgotten about.
Now, what's so wild about this is that while UNESCO is telling these employees they have absolutely no right to a new contract, the organization's own leadership had put a very, very different promise down in writing just a month before.
And here it is, the core contradiction. On one hand, you have UNESCO's action, letting the contract expire. But on the other hand, you have this memo from the Director General himself that said any staff who met the standards for efficiency, competence, and integrity would be offered a renewal. So the employees argued that this memo actually created a right, an expectation of renewal, and that UNESCO had violated it.
So, they took their case to the first stop for justice for international civil servants, the Administrative Tribunal of the International Labor Organization, or ILO. You can think of this as basically the HR court for a lot of these big global bodies. It's designed to settle workplace disputes between the organizations and their staff. And you know what? The tribunal totally sided with the employees. It ruled that the Director General's memo was in fact binding and that UNESCO had acted improperly. They ordered the organization to reverse its decision. A huge, clear victory for Mr. Duberg and his colleagues. But UNESCO was not about to take that loss lying down.
So instead of complying with the ruling, UNESCO did something pretty dramatic. It decided to challenge the very authority of the court that had just ruled against it. They escalated the whole thing, taking the case to the International Court of Justice in The Hague.
And this document right here, this is the moment it became real. This is the actual letter from UNESCO's Director General to the President of the ICJ, formally asking the court to step in. The fight was going to the main event. Now, UNESCO didn't ask the ICJ to retry the case on the facts. No, instead, it asked 3 huge questions about power. First, was the ILO tribunal even allowed to hear this case in the first place? Second, could it really second-guess the Director General's authority? And third, based on all that, are these rulings against us even valid?
The ICJ was asked for something called an advisory opinion. Now, normally that's just non-binding advice, but, and this is the absolute kicker, the rules of the ILO tribunal had a special clause. It said that if UNESCO challenged a ruling on these grounds and asked the ICJ for its opinion, that opinion would be final and legally binding. There were no more appeals after this. This was it.
So, the stage was set. The highest court in the world looked at the case, listened to the arguments, and prepared to answer this fundamental question of whether an international organization has to play by the rules of the courts it agreed to recognize.
So did it? Did this lower tribunal actually have the authority to tell a powerful UN agency that it was wrong? I mean, the entire case and the careers of 4 people were hanging in the balance.
This really gets to the heart of the whole thing. UNESCO's argument was simple. A fixed-term contract is just that, fixed. When it's over, it's over. You don't have a right to a new one. But the ICJ found that UNESCO's own words had completely changed the game. That memo promising renewals, that wasn't just a nice little note. It was effectively a change to their employment terms. It created a legitimate ground for complaint, which meant the tribunal absolutely had the jurisdiction to hear the case.
And the court's decision wasn't even close. By a vote of 10-3, the judges confirmed that, yes, the ILO Administrative Tribunal was in fact competent to hear and to rule on the complaints against UNESCO.
And with that, the legal war was over. The ICJ's final opinion said that the original judgments for the employees were, and I'm quoting here, no longer open to challenge. UNESCO had taken its shot and it had lost. The employees had won.
So why are we digging up a contract dispute from more than half a century ago? Because the impact of this ruling went so much further than just the 4 people involved. It actually carved out a vital principle in international law.
This case cemented this hugely important idea. Powerful institutions are not above the law. When an international body creates rules for its staff and then creates a judicial system to enforce those rules, it has to respect both. It can't just throw out a verdict it doesn't happen to like. This was truly a landmark moment for accountability on the world stage.
And it leaves us with a question that is just as relevant today as it was back in 1956. In a world full of powerful global organizations, from tech giants to international bodies, the question of who holds them accountable and how is still one of the most important challenges we all face. This case was one very early and very crucial answer.